do it? Wonderful. This will be much easier. So public access. That generally speaking, that's the what we call the Indiana Open Door Law. Sometimes you'll see it abbreviated as ODL, the three initials. And then there's the Public Records Act, which is the acronym is the APRA. It lists out the name of this thing. So let's get started. Okay, this is the disclaimer. Just like David said to you, please don't cite the county handbook as official legal authority when you're arguing with someone. This is Ice Miller's requirement of me that I add this so that you don't cite this as legal authority either. But based on this, feel free to give us a call. And I know this is going to be posted to the website if it hasn't been already, so you can thumb through it. Actually, yeah, this is the smaller one, but that's okay. All right, next page. So we've already done this. I'm also going to talk about the public access counselor, and David's already mentioned him, and you will hear him or her mentioned frequently throughout your tenure in public office. Things I'm not going to talk about. Ready? Yep, ready. I'm not going to talk about statutes that govern access to public records outside Title V. There's some in Title X, which has to deal with Homeland Security. There are provisions in Title 16, which deal with county health departments. Title 35, which is criminal law. Not going to talk about those. Not going to talk about the fees that county recorders impose for recording documents. I'm not going to talk about certifying fees that auditors can charge for certain documents that are outside Title V, or I'm not going to talk about bulk copies. I'm not going to talk about access to adoption records or access to court records, statutes that require publication in a newspaper of notices. Not going to talk about law enforcement records or healthcare records. Okay, so what am I going to talk about? First thing you need to know is that the public access laws have a public purpose, which generally means that the business of government belongs to the public. And it is to be conducted in the open, in the sunshine, and sometimes you'll hear these statutes referred to as sunshine laws too. Government is supposed to be open and accessible to the public, and these laws are always liberally construed in favor of access. So if there's ever a question about whether a record should or should not be disclosed, a court is going to find, generally speaking, in favor of access. Similarly, if a meeting should be open and it's not been open, or there's been some sort of process that should have been open to the public and it wasn't conducted in the public's eye, a court is more likely than not to say it should have been conducted in the open and start over. Okay. So we'll start with access to public records. And I forget who's all here today. These are auditors and treasurers. Oh, you guys are the people who have lots of records, and council members. So you guys are actually governing bodies too. Okay, access to public records. The code site is, if you need it, is IC 5-14-3. Okay. There are definitions in the public record statute which are very, very important. Copy. A copy is just about any way you can reproduce a document or an image. So the statute was written like 35 years ago, so a lot of it hasn't kept up with technology. But basically, if there's a way to make another image of it, that's a copy. Inspecting is the right to take a look at the document, to make notes of it. If it's an oral record, they have to be able to transcribe it. And if it's electronically stored, like on your thumb drives, they have to be able to access the information electronically. Okay. Public record. This is very important. It's virtually any writing, any report, any study, any photo, any map, virtually any kind of information that is created. I love this list. Created, received, maintained, retained, or filed. Virtually, if you have it, it's a public record. Doesn't matter what form it's in. If it's got information on it, it is a public record. Every record in the possession of county government is a public record. Having said that, the Public Records Act recognizes 3 categories of public records. There are confidential records, which may not be disclosed unless a court orders you to do so in discovery when you're in a lawsuit. So those are, it's a fairly short list. The things that are important are if it's already been declared confidential by state or federal law, if it's been declared confidential by the rules of the Indiana Supreme Court. You can keep going. Okay, you can keep going too. Okay, keep going. So let's see. Records that contain trade secrets, that contain confidential financial information that you've asked someone to provide you. And then Social Security numbers. And the recorders were here last week, and they're all shaking their heads. We know that we can't disclose Social Security numbers. Pain of death, I think, or something like that. Okay. Personnel files, generally speaking, are not disclosable unless you want to disclose them. You went too far. We're going to start. Okay, we had confidential records. Now we've got discretionary records. I should back up. Discretionary records are records that the public agency may, in its own discretion, determine that it will or will not release. And there's a fairly long list of these, and it grows every year. Probably the one that most of you will have the most dealings with are going to be personnel records. Generally speaking, those are discretionary, so you can release them or you don't have to release them, except certain information you have to release, like their name, the compensation, virtually almost everything about them except maybe their home address and phone number. You have to release information if they're like the subject of a disciplinary matter or an investigation, and the factual basis for any disciplinary action you take. Now, this is going to usually takes place more in the law enforcement context, but you may actually have disciplinary proceedings against other kinds of county employees too. And it's up to you to decide, generally speaking, what personnel records you're going to release, but these are things that must be released. Okay. Records that are, this is another one that especially county councils will have a lot of interaction with. Records that are either interagency, so between agencies, or intra-agency, so within the agency, deliberative material, even material that's developed by a consultant, so long as those materials are speculative, contain maybe opinions, that, you know, a straight, simple document that has facts that are just not questionable, that's probably not a deliberative or an interagency deliberative material. But you can try it. Diaries or journals. For those of you who are in, keep like a schedule for someone, and it has public and private parts. Those things you can decide you will or you won't disclose. And then county councils, again, this is another one that will be important for county councils. Records relating to negotiations between you and an economic development prospect. Those things you don't have to release if you don't want to, but once you have terminated negotiations and you've either come to a meeting of the minds or you've decided there is no meeting of the minds, the final offer and the contents of that are disclosable and must be disclosed. Okay. Then, if it isn't one of those things that I've already discussed, so confidential or discretionary, everything else must be disclosed. It's a lot of stuff. If a public record contains disclosable and non-disclosable information, you have to mask the information or separate it or redact it in such a way that the non-disclosable information is not disclosed. Okay. Generally speaking, anybody has the right, the privilege to inspect and copy the public records of any public agency during normal business hours of the agency. A request for to inspect or copy a record has to identify with reasonable particularity, and that's not been litigated yet, so it's a very broad definition. The record that is being requested. So say I would like to see the contracts that were approved at the January 27th meeting of the commissioners. That's probably pretty specific. A record or a request that says, I want to see all the contracts that have been approved in the last 10 years is probably not very specific. So that's a weighing sort of thing. At your discretion, a request for inspection and copying may be in writing, and I strongly urge all my clients and just you all generally, you might want to go ahead and adopt a policy to have records requests made in writing. It protects you a little bit, and it gives you a little bit more time to respond to them. Now, again, this is another thing that hasn't litigated. Within a reasonable time after the request is received, and then there's some further specificity later on in the statute, the public agency either has to provide access, the requested copies, or allow the person to make copies on your equipment or on their equipment. You can charge a fee not to exceed 10 cents a page for black and white copies and not to exceed 25 cents a page for color copies, unless your agency can demonstrate that it costs you in excess of the 10 cents to produce a black and white copy or 25 cents to produce a color copy. But you have to do a detailed study because the statute's very clear. It has to be the direct cost of producing the record. Can't include the time that it takes your assistant to walk over to the annex and dig through the files that are 50 years old to find the document. It's just actually the copy of the document, the ink and toner, perhaps. Let's see. You can require payment in advance. For instance, if someone comes in and says, I would like copies of da-da-da-da-da-da-da-da, and you can tell them it's going to take us a while to find that. But before we produce you copies, we're going to expect you to pay in advance. You can do that. And sometimes that sort of narrows down fishing expeditions where someone thought, well, I'll just come in and ask for all the emails for the last 15 years. And when you say, okay, that'll be 10 cents a page, and we print each email, however many pages it does. And as you know, a lot of times when you print an email, you get everything and then one little snippet on the next page. So you got 20 cents. That adds up. So by the time you present them a bill for $5,000 for all these copies, they may say, I don't think I need that many copies. So county public agencies may charge a certification fee. This is different than the auditor's certifications. This is sometimes you're asked, particularly in litigation or other things, to certify that the minutes or this resolution or this ordinance are in fact the true legal and official record of the county, and you can charge for that certification too. You can't deny someone access to a record simply because they're not going to tell you why they want it, unless there's a statute that requires it, and I don't know of any statute that requires somebody to tell you why they want a record. Maybe when you're in litigation and under the rules of discovery. You can't interfere with a person's right to inspect and copy a public record, and you can't adopt a rule or a procedure that imposes any costs for looking up public records or the research that's involved. Denial. If you determine that you're going to deny access to a record, it can happen in a variety of ways. If they've come in person, knocked on your desk and said, I would like this document, and you know that it is a confidential document that you may not disclose, that you're absolutely not to disclose, or if they call you on the telephone, or if more likely now they send you an email, and you guys may even be getting texts now if you have allowed your cell phone number to be released. The person who you have designated in your office to be the gatekeeper to public records denies or refuses to permit the access, or 24 hours after anybody in your office says you can't have the document. If a request is made orally and then is renewed, or either in person or by telephone, you can deny it orally. Now, let's go back to what I said about having requests made in writing. If you get a request in writing, I think even though the statute doesn't require it, I would put the denial in writing. That I would actually have a two-step process where they submitted their request in writing, you acknowledge that you received it on such and such a date, and then you make a reasonable effort. You tell them you're going to make a reasonable effort to determine what documents are or are not disclosable and get back to them in a reasonable amount of time. Reasonable is in the eye of the beholder. Okay. If you're sent a letter requesting a public record, or if they send you a fax requesting it, denial occurs if you don't respond to them within 7 days after the request is made. And respond doesn't necessarily mean produce. It means acknowledge that you've received the request and that you're working on it. If you don't at least let them know that you've received the request, most courts, and I think the Public Access Counselor has said, that kind of works as a denial when you hit that 7th day. So within that period, if you've received it in writing, respond in writing that you've got the request and you're working on it. If it's made in writing and then it's renewed orally, like they make it in writing and then they call you on the telephone, you can deny the request in basically the format that they sent it to you in. If a person is denied access to a public record, they can file a lawsuit. The burden of proof is on the public agency to prove that they should not or cannot disclose either a confidential or discretionary record. And the courts have said it's kind of on a case-by-case basis. And even though the statute says it's in your discretion, you got to really come up with a good reason why a discretionary record is not going to be disclosed. The denial can't be arbitrary or capricious. In other words, you need to have, especially for discretionary records, some sort of, you treat these records kind of uniformly. You don't say this company can have the records and this company who's their direct competitor can't. That's probably arbitrary and capricious. Okay. There are also civil penalties. Go back here to attorney's fees. In order to sort of encourage local governments, and I guess the state government, to be open and provide records, people who file lawsuits get attorney's fees if, before they file the lawsuit, they go to the Public Access Counselor and ask for and receive a formal opinion that agrees essentially with them that they should have had access to the document. They don't get that opinion, they're not entitled to attorney's fees unless there was such an emergency that they had to file a lawsuit before they sought a Public Access Counselor's opinion. Okay, in addition to the lawsuit, court may also, and ordering you to, remedies may include ordering you to release the document, et cetera, and so forth. The court can impose civil penalties. That's dollar fines, penalties imposed against the public official or the public agency itself for knowingly and intentionally and with bad faith, basically, refusing to allow access to a document. First offense is $100, and then any further offenses could be up to $500. Okay? That was records. Now we're going to do open door law. Okay? Definitions are important. Really, really, really important. A meeting is a gathering of a majority of the governing body of a public agency for the purpose of taking official action on public business. Meetings defined, gatherings defined, but we're not going to talk about that. Governing bodies defined, public agencies defined, official action, and public business are all defined in this statute. So it's really, really important that you know whether you fall under the definitions. An executive session is a meeting from which the public's excluded. It continues to be a meeting, even though the public is not invited to attend or permitted to attend. Things that are not a meeting. A social chance, and the statute says chance gathering, not intended to avoid the statute. If 4 members of the council want to go to lunch, that's generally not a meeting. If all of the commissioners want to have breakfast together, it's probably not a meeting. I'd be careful, but it's probably not a meeting. Going off-site from, say, the courthouse or the annex, the county building, in order to make an inspection of a program or a company or a project or a facility, that's not, generally speaking, a meeting. Even though you may be receiving information, it's not a meeting. It's like if you're going to go tour the latest version of county jails in the state of Indiana, is to look at what you might need to be doing to bring your county jail up to speed. That's not a meeting. Traveling to and attending meetings that are devoted to the betterment of government. This is not a meeting under the open door law. Okay, a governing body. 2 or more individuals who are a board or a commission, any committee appointed directly by the governing body or its presiding officer. And there's even been a case involving the town of, now it's city officials, that even a sort of an ad hoc group that kind of gets together may become a governing body subject to the open door law. Official action. Receiving information is official action. Deliberating, discussing, making recommendations, establishing policy, making a decision, taking a vote. Those are all official action. But I want to go back to the first one. Receiving information is official action that, generally speaking, must take place in a public meeting. Final action is voting, and it must always take place in an open meeting. And public business, this is so broad you can drive a semi-truck through it. It's any function upon which the public agency is empowered or authorized to take official action. So anything that you're authorized to receive information about is public business. General requirements, and I can't overemphasize this, with a few exceptions, every meeting of a governing body must be open at all times for the purpose of permitting members of the public to observe and record them. There is case law that says you have to allow the media in with their cameras or their tape recorders or whatever they're using now instead of tape recorders. Litigation went all the way to the Supreme Court in 1990 that says, oh yeah, they have to be permitted to record. Okay. Basic notice requirements for all public meetings. You must provide notice of the date, the time, and the place. It has to be given for all meetings of your governing body. The notice must be given at least 48 hours prior to the time of the meeting, and you cannot include in the 48 hours Saturdays, Sundays, or legal holidays. So Thanksgiving weekend created some problems in terms of meeting 48 hours for folks because a lot of counties if the legal holiday was Thanksgiving, then even though Friday isn't a legal holiday, nobody's around but Saturday and Sunday, so people were having to post like Tuesday afternoon in order to meet Monday just to make sure that they hit the 48 hours. Notice must be posted, I mean taped or hung or stapled or nailed or whatever, at the principal office of the public agency that's meeting. So if the council has an office in the courthouse or the government building, that's where you post it. If the agency doesn't have a principal office, then you post it outside or at the building, the place where the meeting is to take place. And a lot of times you'll see a notice that something is meeting in the courthouse on the front door of the courthouse. Doesn't have to be published in the newspaper. It has to be posted. If you have news media who've asked annually to receive your meeting notices, you must also provide it to them. But they must file it by December 31st for the upcoming year. So, go ahead. You only have to do it if the media has asked for it. Now, having said that, I think you have to make a decision about, is it worth your headache or litigation or bad headlines in the paper because somehow or another you haven't provided them, like a notice that's got type this big on it telling them that you're meeting, because sometimes they don't pay attention. So, but it only has to be if they've asked for it annually. Now, if the agency wasn't, say it's a new agency that the commissioners create like in June, obviously there was no way they could file before December 31st. So then I think you assume that a written request made as of the date after the agency was established is probably good. It's probably just good practice to send your local newspapers, local radio stations, notice of meetings, even if they haven't asked for it. Okay. When the media requests, you can give it to them in one of three ways. They don't have to. They don't get to tell you what way they want to receive it. You get to choose. So you can send them notices in the mail. You can send them a notice of a meeting by email, if you've got an email system that works. Or you can send it by fax. Well, yeah, I know, but there are some places who still aren't computers, and who don't routinely use email. There are probably like 3 of them in the southern part of the state. But anyway, you get to decide how you're going to give them notice. They don't get to tell you how they're getting notice. They may try to change that at some point, but whatever. Okay. Am I next? Okay. In addition to this, the governing body can adopt a policy, and please don't do this, but the statute says you can. You can adopt a notice to provide, or a policy to provide additional notice by electronic means. Anybody who requests email notification, not just news media, anybody, if you have such a policy, who requests annually, you have to send them an email notice of every meeting. So this could be every nutcase in the county. If they send, and of course you don't have any nutcases in your counties, I know that. If they ask, or there are troublemakers, or there are folks who are perceived as troublemakers, or if they send you an email, if they request it, you got to send it. And think about, if you've got something really controversial going on in your county, how many hundreds of emails that could be you have to send out every time the commissioners meet, or every time the council meets, or every time the redevelopment commission meets, or whatever. Or you can post it on your website, so which means kind of like you got to have a place on your website that's available. The state actually has a page that's called the state meeting calendar. And there are probably a lot of local entities who do something similar, but sort of identifies this agency's meeting, here's the date, time, place, whatever, if you adopt that additional policy. But I would think twice about that. but that's up to you. You have to keep at least a memoranda of all public meetings. And the memoranda needs to include the date, the time, and the place, which you take off the notice, the members of the governing body who attended and who didn't attend, the general substance of the matters you discuss, and if there are votes taken, you have to record them by individual members if there's a roll call. If the vote is simply all those in favor say aye, and you can figure out it's 3-2 or 4-3 or 2-1. But if somebody says I want to call the roll, then you have to record, that it's Counselor X did this, Counselor Y voted no, Counselor Q voted yes, Counselor G abstained. The memoranda have to be available within, again, this word reasonable, period of time after the meeting for the purpose of informing the public about what happened. If you have minutes, they're supposed to be open for inspection and copying. And notice that you don't have to have minutes, but you do have to have memoranda under the open door law. There are other reasons that the State Board of Accounts is going to explain to you tomorrow about why you want to have minutes. Okay. Under a few circumstances, you can have an executive session. You can exclude members of the public from it. You can invite people to attend, but experts, professionals, or somebody that that you need to talk with. Public notice is still required, so got the 48-hour requirement and the posting outside the principal office or outside the meeting place. But the notice also has to include the statutory exception for which you're having an executive session. There are several. You can go ahead, yeah. And the most common ones are where a state or federal statute authorizes it. That's pretty slim. For discussion of strategy with respect to certain kinds of things, like initiation of litigation, if you're going to talk about strategy related to collective bargaining or the purchase or lease of real property, you can have you can go ahead. You can have an executive session to receive and interview prospective employees, for disciplinary kind of things, for any individual over whom you have jurisdiction, to receive information about conduct and to discuss before you decide whether that person should remain an employee or not. When you're making an appointment of a public official. Usually this is going to be something the county council might do or the county commissioners might be doing, so it won't apply to most of you. Okay. You can have an executive session to discuss a job performance evaluation. And but you have to discuss salary, benefits, and compensation in a budget process in an open session. And you can have an executive session to discuss records that are confidential under state or federal statute. So if you've got a public record over here that's confidential, absolutely confidential, or is a discretionary confidential, you can discuss it in an executive session. But that could be the only thing you're discussing in that executive session. Okay. Again, interviews, this will be county councils. You can interview and negotiate with economic development prospects in an executive session. Again, must have notice, et cetera, and so forth. There are remedies for violations of the open door law. If someone thinks that there's been a violation, that they should have been allowed access to a meeting, or that there was official action took place at Joe's coffee shop, anybody can file a lawsuit to get a declaratory judgment that says what they did was invalid or illegal. They can file a lawsuit to get an injunction to prevent them from doing anything further that's in violation of the statute, or to render something that they've done void. The lawsuit must be filed if the conduct that they're going to complain about is the issuance of bonds, that somehow they met in secret to approve the issuance of bonds. And this was a recent issue up in the city of Westfield. You have to do it before the bonds are issued. It's too late after the bonds are issued, even if it's a relatively quick time period. Or within 30 days of the occurrence of the violation, or when you should have known about the occurrence of the violation. So then a court can take a look and figure out whether it's a really egregious violation or it's just simply you didn't post the notices properly, or you had an entity that didn't realize they were a public body and so they weren't having public meetings. Court can sort of craft a remedy to fit what the judge thinks is appropriate for the situation. Okay. Now you go the other way, unless I copied it twice. And then just as with the Public Records Act, a court may impose civil penalties for violations of the open door law. And again, it's knowingly and intentionally and probably with bad faith that you don't give notice of either a regular meeting or an executive session. If you take votes in secret, if you participate in a secret ballot vote. And secret ballots are not allowed under Indiana law, but sometimes people try to get away with it. Or you discuss a subject that's not eligible in an executive session. A lot of folks think that there's an executive session exception for personnel matters. It has to be one of the specifically enumerated exceptions under the statute, and personnel matters is not one of them. If you fail to prepare a memorandum of a meeting, it's kind of knowingly, intentionally. So at least be taking notes. They don't necessarily have to be beautiful, minutes, but at least you got to have that memorandum. If you don't have a memorandum, you're in trouble. Again, it's $100 for the first offense. It could be up to $500 for subsequent offenses, and it can be imposed against the person who failed to post the notice or failed to prepare the memorandum. Can also be imposed against the agency. It has to come out of your pocket. If you as an individual are penalized, it comes out of your pocket. It doesn't come out of the county's treasury. Okay. Then, public access counselor. This is an office that Frank O'Bannon created back, I want to say, in 2004, maybe. There have been 7 or 8 of them. And they're kind of like the Attorney General, except that the public access counselor's area of expertise is focused on the Public Records Act and the Open Door Law, retention of public records, destruction of public records. And the public access counselor was tasked to do a certain number of things. And the public access counselor does have a lovely publication that kind of explains in greater detail both the Open Door Law and the Public Records Act. But probably the most important function the public access counselor does is issue informal and formal advisory opinions about virtually any topic that touches on either the Open Door or the Public Records Act. The most recent iteration is this notion that of, what do we call it? Simultaneous communication. The Open Door Law has been kind of vague about whether having a telephone conversation constitutes a meeting. Fairly recently, the Public Access Counselor issued an opinion. I think it's formal opinion 161-2014 or something like that, that essentially says simultaneous communication, or in other words, telephone communication between 2 members of a 3-member governing body is a meeting. So I don't necessarily agree with that, particularly with regard to commissioners, because there's a specific exception for commissioners when they're acting in the administrative capacity, when they're receiving information, not when they're awarding contracts or making disciplinary decisions, but when they're basically hearing from department heads, that sort of thing, that I think the public access counselor kind of ignored. And I will tell you what we say in most law firms say, the opinion of the public access counselor is as good as the paper it is written on. So it's not a decision by a judge. Now, if someone would, decide to try to get a court to clarify this, then we might know for sure that don't pick up the phone and talk to another member of the governing body. But for now, I think it's okay to have a telephone conversation. Any questions? Are we done? In the back. Yes. Are you wanting me to distinguish between emails on your... Okay. Remember the notion about received, maintained, obtained, retained, whatever. If you've got an email on a public computer, it's a public record. If you have an email on your private email account dealing with public business, that's also a public record. Doesn't matter that it's on your private email. If it deals with public business, it's still a public record. Over here.
That was going to be part of my question too. With electronics being what they are today, the use of personal electronics versus electronics that have been purchased or provided for by your unit of government. So I want clarification on that. And also, thought it might be good just to say something about discussion of items outside the executive sessions.
Okay. The public email account or public email device or publicly provided cell phone versus a private one is kind of analogous to a decision, I can't remember, I think 1994, where the town of Knightstown insisted that if the bills for their that their town attorney presented to them for legal services were always kept at his office and never, past the courthouse doors, that those were somehow not public records. And the court said, you have to be kidding. It's public money. You, as a council, voted to approve that. Of course it's a public record. I don't care where you keep it. It's a public record. So that's kind of the analogy, that you can't, if you've got information about, say, a bid or something like that, and remember, it's virtually anything, if it's on your private email account, it's still a public record. So what we have been suggesting to folks who don't have email policies is that they think about adopting one and encouraging folks to use a private email account for their private correspondence. Now, having said that, I get Ice Miller email and personal email and spam and you name it on one cell phone. So it's kind of trying to figure out where which piece goes is kind of difficult, and for public officials probably even more so. But just remember, you're not protected just because you got it on your Yahoo account as opposed to your clinton.co.in.us account. So now on executive sessions, what was the, spell it out.
We have an executive
Session. Mm-hmm.
and items are discussed by one member of that session outside the session. Does that then violate confidentiality for everybody else who is a part of the session?
I think this question just came up the other day. There's not really, in the same way that there's like attorney-client privilege. You may want to, take that member of your governing body out and thump them if they're, but if it's still the public business ultimately. So, if they run to the newspaper after you've all had a very, let's say you're in an executive session to discuss a huge industrial prospect that might be coming to town. It might mean hundreds of jobs. Depending on the county, it might be tens of jobs, and it would still have the same sort of economic impact. And everybody knows, we have to keep this quiet. We have to call it Project Susie Q or something like that, because we can't reveal who it is. And then somebody runs out and goes to the newspaper and says, oh, by the way, Walmart's coming to town with a huge distribution center. I would take them out and thump them, but there's no legal remedy. Anybody else? Over here.
Set up a separate email account for your conversations regarding county business with wherever. And anything that strays into another account, you put that in that account. Does that satisfy if somebody wants to dump that in?
Yeah, that probably will take care of it. Yeah.
That's what I do.
Yeah, and that's great advice. If for some reason, and I know people see you in the grocery store, so of course they know that your account is XYZ, and they just go ahead and send you stuff on your private account. Dump it into your, forward it to your public account. That way, when, as you say, somebody comes in with a public records request and wants to see all the emails on Commissioner Jones's cell phone, at least it's on that cell phone, and he's not looking at the discussions you're having with your bank about taking out a loan to do this or that or the other, which you definitely don't want in the public. But somehow or another, if a newspaper or a radio reporter sees it, is going to end up somehow or another, or in the church bulletin next week. Okay?